Now back to the show. This is You and the Law with Sterling Fox on AM 650.
Nice to have you with us today. Our guests in studio, Joe Murphy and Scott Stanley from Murphy Batista LLP in Vancouver, personal injury lawyers. And gentlemen, just before the break, we were talking about fiduciary duties that lawyers owe to their clients. And I asked if you wouldn't mind to flip that coin and talk about the client side of that equation and what reasonable expectations any client should have met when engaging the services of a lawyer.
I'm going to let Joe answer that. I think he understands that better than any lawyer I've ever worked with.
All right, Mr. Murphy?
Sterling, the clients that come in to see us are usually shortly after an accident and usually shortly after a very serious accident and bad injuries. And what we do, and I think this is part of our duty to the clients, is we make sure they're accessing the rehab they need.
Okay.
And oftentimes they're not. We help in organizing a care team. We make sure that an occupational therapist has been hired to coordinate and lead the care team. We help them access specialists that we have used in the past or had to help our clients in the past. We look carefully at what the evidence is that tells us when a case can be finished. And you can't finish a case too soon. The dust has to settle. We spend a lot of time talking to people. We talk to our clients, but more importantly, we talk to the mother and the father and the brother and the sister and the husband and the wife.
Can I interrupt
and the
you
aunt and the uncle.
Just a second. You can't finish a case too soon because sometimes the dust has to settle. That would be to allow the consequences of an injury to become apparent, correct?
Exactly.
Okay.
Exactly. There are some injuries. If you've had a spinal cord injury in an accident, it's pretty obvious fairly early on what the long-term needs are.
Right.
But if you've had a brain injury, particularly brain injury to a child, you have to wait a long time before the dust settles. And Sterling, I had a 2-year-old child. I had one child who was 9 months. I had another child who was 4. And unless there was not enough insurance money where we just settled for what was available, I waited till these children were 19 or 20 before the case is finished. And it was only then that I understood what their functioning was. And it was only then that I could get proper expert reports that talked about their long-term problems and the long-term care needs.
And in the case of children, young people injured early in their lives, there is more latitude in terms of time lapse to resolve a case, whereas if it happens to an adult, there's a shorter resolution window. Is that right, Scott? You have to settle sooner as a grown-up than you would as a small person?
Well, when you're an adult, you've generally got 2 years to start a lawsuit if you've been injured.
Okay.
And little kids, they have until they're 21, before their 21st birthday, because the limitation period is suspended until that time. But increasingly, I think there's more pressure to resolve infant claims sooner.
Mm-hmm. And
See, a good example of the fiduciary duty, Sterling, is this. If I'm acting for a child, and I acted for one girl who was 15 who suffered a terrible brain injury in an accident, and I met with the insurance company, ICBC, about 9 months after the accident, and they said, here's $3 million to settle the claim.
Mm-hmm.
And we didn't accept that because I believe that the law, as it then was, that said that was all the insurance money available, wasn't right. And we went through a process of a trial and an appeal, and it actually went to the Supreme Court of Canada. And in the end, my client received about $8 million rather than the $3 million.
The 3 was offered. Right.
So it would have been easy for me, without doing much work, to settle for the 3. In the same way with children's claims, you can settle a child brain injury case when a child is 11. The lawyer gets paid and everything's finished, but there is a huge, huge risk. I think it's almost a given that the child's problems at age 19 will be far greater than what
11.
you think they'll be at 11.
Sure.
And that's my experience with every one of my cases where I've acted for a child suffering a brain injury. And as I say, we wait until they're 19.
Mm-hmm. The operative word in almost all of these discussions when it comes to personal injury and claims, Scott, is settle. somewhere along the line, somebody wants somebody to settle. Usually the insurance company wants the person filing the claim, whether it's a car accident or on-the-job accident or whatever the claim may be. That insurance company wants you to settle. They want to close this file and move on. So is there a rule of thumb with respect to settling? Do you just get it over with? Or tell us about that.
Well, everybody wants to settle: the insurance company, the victim, the two lawyers. Actually, the only one that probably doesn't have an economic interest in settling is the defense lawyer, because they get paid the longer the case goes on. But I don't think that causes them to want to promote the cases and keep them going. But this is a good example where the fiduciary duty is fully engaged, because lawyers make more money, or they make the same amount of money in shorter periods of time by settling these cases.
Right.
And there's an economic incentive for lawyers to settle these cases, but a lawyer can't do that. A lawyer has to always be guided by what's in the best interest of the client. Now, the client gets to make the decision.
Mm-hmm.
The lawyer doesn't determine whether the case goes to trial or not, but it's very important the lawyer be aware of what's important to the client and what the client needs. I was involved in a case recently where it wasn't a personal injury case. It was a really nice lady whose house burned down. There was a natural gas leak. And the insurance company, and she actually was caught in the fire herself. She narrowly escaped with her life.
Boy.
But the insurance company somehow concocted this theory that she tried to burn her house down. And of course, it was just nonsense. And we brought them to the media. They came to settle the claim, and they were quite contrite about it. But they wanted to offer her a fraction of what the claim was worth. But for this lady, she needed two things. She needed to have her home rebuilt.
Did the insurance company make it public that they thought that this woman had burned her house down?
As public as they could, you bet.
Really?
You bet.
In a small town.
Lived in a small town.
Oh, where everybody knows everybody and a whisper, and suddenly it's the news, right?
Well, the very fact that the house isn't getting rebuilt
Right.
is innuendo enough to make them think it's suspicious. And
okay.
So what this lady needed is she needed her home back.
Yes.
And more importantly, she needed her good name back.
Mm-hmm.
And it's easy to settle that claim for, say, 60, 70 cents for what it's worth. That might make a good economic settlement in most cases, but it wouldn't allow her to rebuild her home, and it sure as heck wouldn't give her a good name back. So when we went to settle this case, I said to the insurance company, this is not going to be a negotiation. This is going to be a capitulation. You are going to pay her claim fully so she can buy her house back,
Mm-hmm.
or build a house.
Yeah.
And you're going to put a publication in the newspaper confirming that she didn't burn her home, and you're going to give her good name back. And they did that. And I think the reason
without having to go to court to be really
yeah,
Okay.
without having to go to court. And I think they did that because they know that we will go
that
to
would be
trial.
the next step. Right. So there's an implication with Murphy Batista, both of you, that you are a well-known litigating firm. You go to court routinely, and you win a lot. And so when a client comes to Murphy Batista, in many cases, they know that about you, don't they, Joe? They know you guys are, to use an old-fashioned word, gunslingers. You'll go to court for your guy and take it right to the wall if necessary. And you said earlier, many firms never go to court, ever.
Yeah, that's true. How much clients really appreciate that, I don't know. But the key, Sterling, the key to understand is we don't, as a rule, go to court on cases. But when we have cases where we see the amount being offered being far less than what we're confident we can
Right.
get at trial,
Right.
that's where we say to the client, we know you don't want to go to court. People don't.
Okay.
But we say, in this case, we believe it's necessary for this reason. And almost always the client will say, yes, let's go. And fortunately, almost always we end up with a result a lot better, sometimes many times better than what has been put on the table. So the decision to settle or go to court is really based on each case. We don't, as a rule, say 1 out of 10, we're just going to pick them and run them to trial. That would be foolish.
Exactly.
But a client needs to and wants to know that there is a good reason before the client will say, okay, let's go to court. And for the insurance company, they have to know that we are ready, willing, and able
Well, I
to
was
do
just going to
that
say, right.
before they're going to put the proper amount of money on the table to settle a case.
Right, because Scott, you've mentioned this on a previous program about there is the insurance business is extremely aware that when Murphy Batista is taking on a case representing a client against their company, these guys will, if necessary, absolutely go to court. It puts the whole game on a different playing field, doesn't it?
Well, they were certainly aware when I was doing defense work. Yeah, they were certainly aware. One of the first things an insurance company will ask their defense lawyer, does this lawyer go to trial, and do they have any success when they go?
Right.
And if the answer to both of those questions are yes, the case is going to be taken more seriously.
And the settlement, as is
Yeah.
which is the bottom line every time, might be a little more forthcoming and of higher dollar value.
Yeah, more probability that it will settle and greater value. We settle about 90 to 95% of our cases. I mean, they take these mediation courses. Lawyers, we have to take continuing education. There's this great mediation course. And the one guy said, look, if you're a lawyer, you can do all these voodoo mind tricks and Jedi mind tricks at mediation. He says, but the most important thing is get your case ready for trial and have a history of taking them to trial.
Right.
That's the only mediation trick you need to have in the bag.
Mm-hmm. Mm-hmm.
Case will settle themselves if you do that.
And Joe, you said you get a lot of calls from people who are seeking advice, and your best advice to many of them is, you don't need a lawyer. This is kind of small potatoes. Here's the formula, and if they've offered you X, then don't settle for anything less than X minus whatever, and off you go. Free call, free advice, and just a lawyer would have kind of made the situation perhaps more complicated than it needed to be.
Well, more complicated, and at the end of the day, these people were further ahead without a lawyer. They just needed to be armed with the value of their claim, which they can usually ballpark following a 10 or 15-minute phone call,
Right.
and tell them how they can go about settling it with ICBC.
Okay.
So, and it takes us a few minutes, and I expect that advice is useful to these people because most of them never come back.
Part of a fiduciary duty is not selling a client something they don't need.
Uh-huh. Okay.
Yeah.
All right, and that's well said. We need to take a quick break here. Our guests on this edition of You and the Law here on AM 650, Joe Murphy and Scott Stanley from the law firm Murphy Batista, LLP, and we'll be right back with lots more.
This is You and the Law. There's more of the show still ahead on AM 650.